Proponents first argue that Proposition 8 is rational because it preserves 1. The traditional institution of marriage as the union of a man and a woman. 2. The traditional social and legal purposes, functions, and structure of marriage. And 3. The traditional meaning of marriage as it has always been defined in the English language. These interests relate to maintaining the definition of marriage as the union of a man and a woman for its own sake. Tradition alone, however, cannot form a rational basis for a law. The ancient lineage of a classification does not make it rational. Rather, the state must have an interest apart from the fact of the tradition itself. The evidence shows that tradition of restricting an individual's choice of spouse based on gender does not rationally further a state interest despite its ancient lineage. Instead, the evidence shows that the tradition of gender restrictions arose when spouses were legally required to adhere to specific gender roles. California has eliminated all legally mandated gender roles except the requirement that a marriage consist of a man and a woman. Proposition 8 thus enshrines in the California Constitution a gender restriction that the evidence shows to be nothing more than an artifact of a foregone notion that men and women fulfill different roles in civic life. The tradition of restricting marriage to opposite-sex couples does not further any state interest. Rather, the evidence shows that Proposition 8 harms the state's interest in equality because it mandates that men and women be treated differently based only on antiquated and discredited notions of gender. Proponents' argument that tradition prefers opposite-sex couples to same-sex couples equates to the notion that opposite-sex relationships are simply better than same-sex relationships. Tradition alone cannot legitimate this purported interest. Plaintiffs presented evidence showing conclusively that the state has no interest in preferring opposite-sex couples to same-sex couples, or in preferring heterosexuality to homosexuality. Moreover, the state cannot have an interest in disadvantaging an unpopular minority group simply because the group is unpopular. The evidence shows that the state advances nothing when it adheres to the tradition of excluding same-sex couples from marriage. Proponents' asserted state interests in tradition are nothing more than tautologies and do not amount to a rational basis for Proposition 8. Proponents next argue that Proposition 8 is related to state interests in 1. Acting incrementally with caution when considering a radical transformation to the fundamental nature of a bedrock social institution, and 2. Decreasing the probability of weakening the institution of marriage, and 3. Decreasing the probability of adverse consequences that could result from the weakening of the institution of marriage, and 4. Decreasing the probability of the potential adverse consequences of same-sex marriage. Plaintiffs presented evidence at trial sufficient to rebut any claim that marriage for same-sex couples amounts to a sweeping social change. Instead, the evidence shows beyond debate that allowing same-sex couples to marry has at least a neutral, if not positive, effect on the institution of marriage, and that same-sex couples' marriages would benefit the state. Moreover, the evidence shows that the rights of those opposed to homosexuality or same-sex couples will remain unaffected if the state ceases to enforce Proposition 8. Indeed, proponents presented no reliable evidence that allowing same-sex couples to marry will have any negative effects on society or on the institution of marriage. The process of allowing same-sex couples to marry is straightforward, and no evidence suggests that the state needs any significant lead time to integrate same-sex couples into marriage. Okay, blah, blah, blah. I'm just going to skip a little bit there because it says see background and refers to an earlier bit. The evidence shows that allowing same-sex couples to marry will be simple for California to implement because it has already done so. No change need be phased in. California need not restructure any institution to allow same-sex couples to marry. Because the evidence shows same-sex marriage has and will have no adverse effects on society or the institution of marriage, California has no interest in waiting and no practical need to wait to grant marriage licenses to same-sex couples. Proposition 8 is thus not rationally related to proponents' purported interests in proceeding with caution when implementing social change. Proponents' largest group of purported state interests relates to the opposite sex parents. Proponents argue Proposition 8, 1, promotes stability and responsibility in naturally procreative relationships. 2, promotes enduring and stable family structures for the responsible raising and care of children by their biological parents. 3, increases the probability that natural procreation will occur within stable, enduring, and supporting family structures. 4, promotes the natural and mutually beneficial bond between parents and their biological children. 5, increases the probability that each child will be raised by both his or her biological parents. And 6, increases the probability that each child will be raised by both a father and a mother. End quote. And 7, increases the probability that each child will have a legally recognized father and mother. That's like 7 different ways of saying the same thing almost, wasn't it? The evidence supports 2 points which together show Proposition 8 does not advance any of the identified interests. 1, same-sex parents and opposite-sex parents are of equal quality. And 2, Proposition 8 does not make it more likely that opposite-sex couples will marry and raise offspring biologically related to both parents. The evidence does not support a finding that California has an interest in preferring opposite-sex parents over same-sex parents. Indeed, the evidence shows beyond any doubt that parents' genders are more irrelevant to children's developmental outcomes. Moreover, Proposition 8 has nothing to do with children, as Proposition 8 simply prevents same-sex couples from marrying. Same-sex couples can have or adopt and raise children. When they do, they are treated identically to opposite-sex parents under California law. Even if California had an interest in preferring opposite-sex parents to same-sex parents, and the evidence plainly shows that California does not, Proposition 8 is not rationally related to that interest because Proposition 8 does not affect who can or should become a parent under California law. To the extent that California has an interest in encouraging sexual activity to occur within marriage, a debatable proposition in light of Lawrence 539, the evidence shows that Proposition 8 to be detrimental to that interest. Because of Proposition 8, same-sex couples are not permitted to engage in sexual activity within marriage. Domestic partnerships in which sexual activity is apparently expected are separate from marriage and thus codify California's encouragement of non-marital sexual activity. To the extent proponents seek to encourage a norm that sexual activity occur within marriage to ensure that reproduction occur within stable households, Proposition 8 discourages that norm because it requires some sexual activity and childbearing and child-rearing to occur outside marriage. Proponents argue Proposition 8 advances a state interest in encouraging the formation of stable households. Instead, the evidence shows that Proposition 8 undermines the state interest because same-sex households have become less stable by the passage of Proposition 8. The inability to marry denies same-sex couples the benefits excuse me, let's try that again. The inability to marry denies same-sex couples the benefits, including stability, attendant to marriage. Proponents failed to put forth any credible evidence that married opposite-sex households are more stable through Proposition 8. The only rational conclusion in light of the evidence is that Proposition 8 makes it less likely that California children will be raised in stable households. None of the interests put forth by proponents relating to parents and children is advanced by Proposition 8. Instead, the evidence shows Proposition 8 disadvantages families and their children. Proponents next argue that Proposition 8 will protect the First Amendment freedom of those who disagree with allowing marriage for couples of the same sex. Proponents argue that Proposition 8, 1, preserves the prerogative and responsibility of parents to provide for the ethical and moral development of education of their own children, and 2, accommodates, quote, the First Amendment rights of individuals and institutions that oppose same-sex marriage on religious or moral grounds. These purported interests fail as a matter of law. Proposition 8 does not affect any First Amendment right or responsibility of parents to educate their children. Californians are prevented from distinguishing between same-sex partners and opposite-sex spouses in public accommodations, as California anti-discrimination law requires identical treatment for same-sex unions and opposite-sex marriages. The evidence shows that Proposition 8 does nothing other than eliminate the right of same-sex couples to marry in California. Proposition 8 is not rationally related to an interest in protecting the rights of those opposed to same-sex couples because, as a matter of law, Proposition 8 does not affect the rights of those opposed to homosexuality or to marriage for the couple of the same sex. To the extent proponents argue that one of the rights of those morally opposed to same-sex unions is the right to prevent same-sex couples from marrying, as explained presently, those individuals' moral views are an insufficient basis upon which to enact legislative classification. Proponents argue that Proposition 8 advances a state interest in treating same-sex couples differently from opposite-sex couples by 1. Using different names for different things, 2. Maintaining the flexibility and separately address the needs of different types of relationships, and 3. Ensuring that California marriages are recognized in other jurisdictions, and 4. Conforming California's definition of marriage to federal law. End quotes. Here, proponents assume a premise that evidence thoroughly rebutted. Rather than being different, same-sex and opposite-sex unions are, for all purposes relevant to California law, exactly the same. The evidence shows conclusively that moral and religious views form the only basis for a belief that same-sex couples are different from opposite-sex couples. The evidence fatally undermines any purported state interest in treating couples differently. Thus, these interests do not provide a rational basis supporting Proposition 8. In addition, proponents appear to claim that Proposition 8 advances a state interest in easing administrative burdens associated with issuing and recognizing marriage licenses. Under precedents such as Craig versus Boren, administrative ease and convenience, quote, are not important government objectives. Even assuming the state were to have an interest in administrative convenience, Proposition 8 actually creates an administrative burden on California because California must maintain a parallel institution for same-sex couples to provide the equivalent rights and benefits afforded to married couples. Domestic partnerships create an institutional scheme that must be regulated separately from marriage. California may determine whether to retain domestic partnerships or eliminate them in the absence of Proposition 8. The court presumes, however, that as long as Proposition 8 is in effect, domestic partnerships and the accompanying administrative burden will remain. Proposition 8 thus hinders rather than advances administrative convenience. Finally, proponents assert that Proposition 8 advances any conceivable legitimate interests identified by the parties, amici, or the court at any stage of the proceedings. But proponents, amici, and the court, despite ample opportunity and full trial, have failed to identify any rational basis Proposition 8 could conceivably advance. Proponents, represented by able and energetic counsel, developed a full trial record in support of Proposition 8. The resulting evidence shows that Proposition 8 simply conflicts with the guarantees of the 14th Amendment. Many of the purported interests identified by proponents are nothing more than fear or unarticulated dislike of same-sex couples. Those interests that are legitimate are unrelated to the classification drawn up by Proposition 8. The evidence shows that by every available metric, opposite-sex couples are not better than their same-sex counterparts. Instead, as partners, parents, and citizens, opposite-sex couples and same-sex couples are equal. Proposition 8 violates the Equal Protection Clause because it does not treat them equally.